I'm Nicole Austin Hillary, and I'm with the Brennan Center for Justice, where I direct our Washington, D.C. office and work. And I'd like to welcome you all to today's panel, Seeking an End to Racial Profiling. I'd also like to doubly welcome and thank you for being here, because one of my esteemed colleagues is moderating a panel next door on voting rights. And we kind of have a bet as to who could get the most people at their panel. So thank you for being here. And I know it's always feast or famine. There are always so many important issues. So we really appreciate you being here today to talk about this very important topic. Before we get started, and I have a chance to introduce my wonderful panelists, I have a few housekeeping duties for you. First, if you've got your cell phone, what do I mean if you got your cell phone? Your cell phone. If you have it on, make sure it's on vibrate or that you've got the ringer down, because they're recording this discussion and we want to make sure there's no interference. And that goes for you guys up here too. Also, I just want to let folks know that this is going to be a robust conversation. And it's going to be a conversation. We don't, although these are very esteemed panelists and they're all super smart and they've got a lot to say about racial profiling, we really want to engage in a discussion on these issues. So we're going to talk to each other, but then we're going to try to make sure that we leave ample time for you all to actually engage us in questions and in discussion as well. So with that, let me turn to quickly introducing the panelists who are here with me today. And I'm not going to go through their bios because you have those. I'm just going to quickly tell you who they are and what they do, and then we're going to jump right into the conversation. To my far right is Keenan Keller. Keenan is the Senior Democratic Counsel for the Judiciary Committee of the United States House of Representatives. And in Keenan's role, he works on a variety of issues and has been someone who has been steeped in the issues of racial justice and very focused on racial profiling, not just in this current Congress, but in previous Congresses. And Keenan will talk to us a little bit about that history. Next to me, to my immediate right, is Sunita Patel. Sunita is staff attorney at the Center for Constitutional Rights. Oh, I'm sorry. See, I'm sorry. Alessandra is next to me. That was actually a test for you guys. Alessandra Solar is next to me. She is the executive director at the American Civil Liberties Union of Arizona. And don't tell all of my friends at the ACLU here in DC, because they will never let me forget it. Alessandra is a litigator and has been involved in some of the most important litigation in this area in our recent past. And we will get into what some of those cases are and how important they are, particularly with respect to Arizona. To my immediate left is Sunita Patel. Sunita is a staff attorney at the Center for Constitutional Rights. She is also a litigator and has been involved in another extremely important case on the other coast, on the East Coast, in New York, the case dealing with racial profiling. And we certainly will spend a great deal of time talking about that. And last but certainly not least is Professor Devin Carbado. Devin is the Honorable Harry Pergerson Professor of Law at the UCLA School of Law. He focuses on critical race theory, as well as employment discrimination and criminal procedure and other criminal justice issues. And he will help us to tie in what this issue of racial profiling means, not just from an academic perspective, but from the perspective of jurisprudence and what it means with respect to our courts and our policy moving forward. So with that, please join me in welcoming our panelists. And Keenan, I'm going to start with you, and it's not just because we work together. That's not why I'm picking on you, but your role as someone who has been a senior staffer, has been for some time a senior staffer on the Hill, means that you have been engaged in these issues not only for quite some time, but at very critical junctures as this concept of racial profiling has evolved over the years. You've seen how the mix of politicians as well as litigators on the outside have attempted to deal with this issue. So I'd love for you to try to just give us a little bit of a lay of the land in terms of kind of where we started and how we evolved to this period from a policy perspective, in terms of how our members of Congress are dealing with this. And then I'd like for that to kind of set the stage for us to then get into some of the cases and how this issue has really come to life in terms of the courts.
Well, the issue of racial profiling truly has evolved. At the beginning of the issue, it started off with driving while black. And when that issue first reached the ears of Representative Conyers, it was this whole notion of an urban myth. Everybody said, oh, well, you know, that couldn't possibly be true. black people driving around and getting pulled over simply because of their race. Nobody believed that. And the police denied and denied and denied it. So the initial legislative phase of racial profiling was all about trying to find quantitative proof of what minority groups had been saying over time with respect to their routine interactions with law enforcement. The first bill that came out of that was Mr. Conyers' Traffic Stop Statistics Study Act. And that bill rattled around Congress for about 4 years, and then in 1999 came up and actually passed on suspension of the rules, which actually meant that enough people, and this was in a Republican-led House under Henry Hyde, it actually went through committee and it had enough support from people like Asa Hutchinson of Arkansas for this to pass without a record vote. The next time it came up, and of course the Senate was also Republican at that time, and it had no prospects there. The next time the issue came up, profiling had evolved because enough litigation had occurred, enough enforcement had begun under Mr. Conyers' 42 U.S.C. 14141, that there was good quantitative data proving that this was in fact the case. So even though there was a desire to move the bill through the legislature again, the issue had shifted to not verifying that this was an actual reality, but actually trying to end the practice. And then we came up with the End Racial Profiling Act. And when George W. Bush won, in his first State of the Union address, he said that racial profiling was wrong and we have to end it. And he challenged Congress to actually pass legislation that year and tasked us to work with then Attorney General John Ashcroft. And on June 6, 2001, the birth date of my youngest daughter, we actually introduced that bill. And we had a hearing in the House, we had a hearing in the Senate, and the bill was set to actually pass that fall in October. That was the target time that it would have been brought forward. Well, you all know that the 9/11 attacks occurred, and then that ended the prospects of the End Racial Profiling Act. Then the issue shifted again to executive authority, and we had the John Ashcroft DOJ President Bush Racial Profiling Guidance, which we still have, and then we're still trying to pass the End Racial Profiling Act. But the 9/11 attacks themselves morphed the issue from routine law enforcement encounters to national security. And after national security, we quickly moved into the whole issue of immigration. So it went from driving while black and brown to flying while Arab to driving while brown within 200 or more miles of the border. And the issue then, all these issues became so tied to one another that you actually couldn't disaggregate it. And there was a push to try and do so, but Mr. Conyers and other progressive voices said, no, racial profiling is racial profiling. So the issue really started off with the whole question of whether this was real to now having units within the federal government saying that, no, we should actually be able to use profiles as part of law enforcement. So it shows you how in a very short period of time an issue can really pivot, and you'll find that you're dealing with, you thought that you were dealing with one thing, but then you find that you're dealing with another and another and another. And then the solutions to it look much more murky, which is kind of where we are right now.
That's perfect, Keenan. Thank you. Alessandra and Sunita, I want to talk about the litigation. Keenan has clearly articulated for us what the policymakers have done and what they've thought and how they've attempted to deal with this. But we know that many times in this country, often the ways that we can bring about real change is through the courts. And you've both dealt with some very important cases. And I want to start with talking about Arizona and what happened in Arizona, particularly with respect to the Whiting case and its progeny, Melendres. Tell us a little bit about those cases and what they meant in terms of elevating this issue to the point where it became a national conversation piece. Certainly when you have I was going to say a character, but not a character, but when you have a face that you can put on the issue, such as Sheriff Arpaio, that makes a difference. That means that people start to pay attention. Tell us about the activities dealing with the sheriff and what that meant in terms of the litigation that was an outgrowth of that activity.
So, and just to piggyback on what Keenan, the landscape that Keenan provided for us, as you said, Nicole, I mean, Sheriff Arpaio is sort of the most extreme and egregious example of what can go wrong when local law enforcement officials engage in the business of immigration enforcement. And at the time, in 2006, 2007, the federal government started to dramatically expand its 287G program, which it was a program that they entered into agreements with local officials, allowing them to enforce immigration laws for the purposes of going after criminal enterprises. I mean, it was very, very explicit. That should have been the focus. What Arpaio did was he basically announced shortly before he signed the 287G that he was going to engage in a campaign of finding and locking up quote-unquote illegals. This was 2005, 2006, and started transferring massive amounts of resources to this campaign. It was a campaign where he was terrorizing Latino community, engaging in very, very aggressive raids, upwards of 40, 50 community crime suppression sweeps, quote unquote crime suppression sweeps, targeting Latinos, both citizens and non-citizens alike. This was under the oversight and watchful eye of our federal government. And I think that was one of the reasons I mentioned this, because ultimately he ended up citing this as a defense, one of his defenses in the case, which the judge kind of ignored and threw out. But the federal government, the 287G program, created a monster. At one point in 2007, there were 160 deputized MCSO agents enforcing federal immigration laws, and they were out there in the communities conducting these raids. Obviously, here we are 7 years later, where it was because of the courts that those practices ended. And it was last year, and it was a historic decision by Judge Murray Snow, who was a Bush appointee. And we had a trial, and he issued a decision, a very strong decision, basically ending prohibiting him from engaging in civil immigration enforcement, and then spelling out a series of court-mandated reforms, including everything from the typical ones that we see in consent decrees, like data collection, early intervention systems. But this one does go beyond, in the sense that the deputies now can no longer stop and question you for the purpose of trying to determine your immigration status, which was what was the issue in this case. And I think the deputies would stop people, many U.S. citizens. Maricopa County, 30% of the residents in Maricopa County are U.S. citizens, are Latinos. The majority of them are U.S. citizens, which means when you are prioritizing immigration enforcement using minor traffic stops as a legal cover, so to speak, to question people about your immigration status, you're going to end up questioning and detaining U.S. citizens, which is exactly what happened. He stopped and asked a mayor's aide for her Social Security card. He would pull over, U.S. citizens and engage in a practice of making law enforcement decisions based on race, because the goal was to ultimately stop and question you and then deport you based on your perceived immigration status. So the good thing is the judge, we're now at the point now, we have this amazing decision. Unlike and I think my colleagues will know how many, but there are probably about 20 different consent decrees that have been instituted either through the Department of Justice or various different cases that on this very same issue. What's unique in this particular situation is that we're dealing with, this was not a consent decree, this was a decision by the judge, and we're dealing with an entity that has not been cooperative. And in fact, and I think that the community is very skeptical, and they should be. I mean, the community was let down by the state of Arizona. They were let down by the federal government, the Latinos in Maricopa County, and they're understandably very skeptical about whether or not these reforms can actually take place with Arpaio as the leader of this embattled agency. I will say, I just want to kind of point out, because I think it was really remarkable what happened yesterday, is as part of the litigation, the judge appointed a monitor, Chief Robert Warshaw. I think he was the former chief in Rochester, New York. And Warshaw had a meeting yesterday. It was the first community meeting where him and his team were there and they were given an opportunity the community was given an opportunity to ask questions about the reforms, to ask questions about the process, what the role of the monitor is going to be in this case, and 200 people showed up. And I think that's really, really important because we're talking about scared, vulnerable, many, many people who are undocumented, who now have stood up and they said, we're not going to take this anymore. And I think that was a really, really positive step in this very, very long process of reform.
Great, thank you so much. Let's pivot to New York. New York, New York. Stop and frisk.
Yep.
How did we get to this point where we had police officers in New York actually targeting mostly black men and stopping them without cause, and the havoc that it created? And what does the recent decision in Floyd portend, not just for New York, but for other jurisdictions where law enforcement might be thinking about utilizing those same types of practices? Has it made it better, not just for folks in New York, but for folks in other states and other cities?
Well, I will say that I just want to build off of a little bit of what Alessandra said and say we have a character in New York too, and that is Michael Bloomberg and Ray Kelly. And
I said not character. Oh, face.
Okay, a face. Yeah, that's even better, a face. The former mayor Bloomberg and police commissioner Ray Kelly, and prior to Ray Kelly, Giuliani. So what we have the same kind of very polarizing character who, in the beginning of the, just wreaked havoc in the Black and Latino communities, and there's really contentious history where you had murders, you had just literally torture techniques happening in the 90s, and this really great momentum around change, and as Keenan mentioned, this real conversation that yes, this is happening. We have to do something about this. And at the Center for Constitutional Rights, we filed a case in 1999 after the death of Amadou Diallo and all these horrendous deaths that were happening in New York City. And after 9/11, there was a real temperament change, in particular in New York, I think obviously around the country, but in New York, it really silenced a very large movement of people who were affected by these policies, not just the lawyers and the policymakers, but the people who were affected by it because they felt afraid to talk about it in the same way and use the same language. So for several years, the sort of momentum on the ground waned, and then you had the death of Sean Bell, which again sort of reached this crescendo in terms of national profile and national attention on the New York Police Department. And at CCR, the statistics and the data we were getting as a result of the settlement in the prior case showed that the problem was only getting worse. From 600,000 or 700,000 stop and frisks a year, you then had upwards of 500,000, and the racial disparity was only getting worse. In 2011, there were almost 700,000 stops. Only 6% of those stops led to arrests, and only another 6% led to summons or other kind of tickets. That doesn't mean that all those 12% led to convictions. The conviction rate was actually much lower because much of that was getting thrown out. So what you had is, you had from the highest levels, a message being sent down to the street beat cops saying, just go out and get black and brown, in particularly young men. But that meant it affected the whole community, girls, women, everybody. And we were able to, there was a trial last year, and a trial put forward testimony of these recordings that had been made by whistleblower cops that really were just shattered any kind of the face of civility that the police department was trying to put out there. And it showed these sergeants and lieutenants saying, just go out there and get them. It said, I want to see a clean street. They said, we own the streets. They might live here, but we own the streets. Take back the streets. So this attitude, this pervasive attitude, not just by white cops, but by black cops and Latino cops and Asian cops, it was a command. It was a command structure. So from the very highest levels. And then I think the thing that really, really shows the pervasive nature of this attitude is that Senator Eric Adams testified at trial and was, is a very well-respected elected official, said he was in a meeting when he was a sergeant at the NYPD where Ray Kelly said, the reason why the numbers are like this, the reason this is happening is because we are gonna target young black and Latino men so that they know not to carry guns. The gun retrieval rate of stop and frisk is not even 0.1%. So that justification is, as the judge found, just a proxy for race. You can't use a criminal profile or crime rates as a proxy for race. So ultimately, we had an amazing decision which was built off of Melendres, and I was telling Alessandra before that I feel extremely excited to be on a panel with her because after the decision came out, I was doing a lot of speaking and saying, who is Commissioner Kelly in the company of, and that is Sheriff Joe Arpaio. These are the only two law enforcement urban police department officials who have been found guilty, or not guilty, but have been found liable at a trial for class action lawsuits. Everyone else settles. Everyone else admits that there's a problem and wants to make change. Why are these two faces not willing to do that? So just coming quickly to the present, Bloomberg vowed to appeal and started slandering the judge halfway through the trial, and so immediately ran to court and appealed, and a stay was put in place by the Second Circuit. But because of the amazing organizing work that was happening on the ground, there was an incredible political moment that happened during the time of the trial. And there was an election that everyone was gearing up for. So for those of you who are not from New York and don't know the inner workings of the politics there, this trial really did help to elect Mayor de Blasio. And he used it as a way of showing how different he was going to be and ran on the fact that he was going to reform stop and frisk and he would drop the appeal. And he was elected. We have papers pending, but the appeal will be dropped. And so I think it's a really interesting question of policy change and litigation and willing and unwilling parties, because now we have a willing party, supposedly. We'll see what happens. But someone who's going to sit at the table with us and try and work out solutions. So our remedy is built, it's a little bit different than a traditional kind of consent decree. What we've asked for is for the judge ordered the court monitor and a facilitator who's someone from the Vera Institute to bring together a variety of stakeholders, police organizations, public defenders, researchers, obviously the plaintiff's class, and organized constituents also to develop the solutions and what the reforms would be. And we can talk more as we move on about how that will look.
Good, because I'm interested in how diverse that group of stakeholders is.
Yes.
Because, I have to tell you, I have a colleague in New York who works on these very issues, and he always says that the way to end racial profiling is to start picking up more white men. And I always find that curious, and he says, well, because then everybody would kind of have a sense of like what this is and would feel like we all have a stake in this. So I'm interested to hear whether they are actually bringing diverse voices and groups around the table to problem solve. And speaking of problem solving, Devin, I know you think that, or I'll let you say what you think, but I know you've written about and you've talked about how you think that the root of some of this problem is in our courts and kind of, decisions that they've made going back to Terry. And how we utilize the Fourth Amendment and what the Fourth Amendment does in terms of the freedoms and access that it gives law enforcement. So talk to us a little bit about that.
Great, I'm happy to. And first I just want to say it's a pleasure to share the panel with such distinguished panelists. I'm not quite sure what I'm doing here, but I'm happy to yab on nonetheless. So my starting point for taking up that question is to say that the general way in which we frame racial profiling is to say that racial profiling is a problem of lawlessness. That is to say, it's a moment in which police officers are operating outside of the permissible boundaries of law. It's a moment of the rogue cop. And indeed, many instances of racial profiling does issue from that particular scenario. But it's helpful as well, I think, for us to understand racial profiling as a problem of law. That is, as a problem that derives from police officers acting within the permissible boundaries of law. And I want to provide some concrete example of what I mean by that. The second broad thing I want to say pertains to the important Floyd litigation in New York. It's a tremendous victory, it seems to me, and it marks an important moment in which legal strategies, litigation, and argumentation converged in important ways with community organization. And I think we need to think about what that model means for solving racial profiling problems going forward. At the same time, I want to say that the Floyd litigation reflects just how much civil rights ground we have lost. So that seemed paradoxical. On the one hand, it's a victory, and on the other hand, I'm saying it reflects a loss, and I want to speak to that issue as well. So the first point, what do I mean to say that racial profiling reflects a problem of law and not just lawlessness? So first of all, how many of you have taken constitutional criminal procedure or remember any of that stuff? So some of you remember some of it. So basically, this is a story about the Fourth Amendment. So you might know that the Fourth Amendment protects us from unreasonable searches and seizures. And what that means concretely is governmental activity that does not constitute a search or a seizure is governmental activity that resides outside of the reach of the Fourth Amendment. So the Fourth Amendment has nothing to say about police conduct that is not a search or seizure. Everyone gets that. The second point is that even if it's a search or seizure, it's not necessarily problematic unless it's deemed to be unreasonable. What I want to say is that the Supreme Court's conclusion that certain police activity that does not constitute a seizure and the Supreme Court's conclusion that certain seizures are reasonable creates legal zones for racial profiling. Here's just a few examples. Let's say Tony's standing on the street corner. Stipulate that the police have no reason to think that Tony's done anything wrong. They approach him, they question him, what are you doing, where are you going, where are you coming from, can I see your ID, where have you been, what's your immigration status, etc. None of that triggers the Fourth Amendment. Let's say they ask Tony for permission to search. May I search your bag? May I search your person? Do they have to instruct Tony that he has a right to refuse consent? No. Again, none of that triggers the Fourth Amendment. Does it matter if we establish as a matter of fact that the officer's conduct with respect to each of those scenarios was racially motivated? The decision to follow, the decision to engage, the decision to question, the decision to ask permission to search. If we say that those are racially motivated, does that mean now that the Fourth Amendment speaks to it? Not at all. So long as it's not a seizure, it doesn't matter if it's racially motivated. So these are just some clear examples where the Supreme Court has said that certain kinds of activity reside outside of the reach of the Fourth Amendment and therefore are zones within which racial profiling can occur. Let's switch for a minute and think about moments where the Supreme Court says that certain kinds of conduct are reasonable. So imagine that I'm driving home from work. Imagine that my colleague is doing the same. Stipulate that one of us is black and the other one is white, and just to avoid any racial confusion, I would be the black guy. Let's say that there are two cops in a car. They observe both of us drive through a traffic light. Cop A says to Cop B, let's stop the black guy. He probably has stuff on him, and I don't like black people. Stipulate that that's the predicate. I am stopped. I bring a Fourth Amendment claim. Is that a problem for the Fourth Amendment? The Supreme Court has expressly said no. So long as the officer has probable cause to believe that I committed a traffic infraction, that's enough. That it's a pretextual stop doesn't matter. That it's racially motivated doesn't matter. That's a reasonable stop under the Fourth Amendment. The Supreme Court says that apparent Mexican ancestry can be a basis for whether or not you're undocumented. You can expressly trade on a person's race to determine their immigration status. So these are simply examples, clear examples, where the problem of racial profiling is not a problem of lawlessness, it's a problem of the rule of law. And as we think about solving the problem going forward, it seems to me that we have to have this broader jurisprudential backdrop in mind.
So given that, litigators, I'm going to ask you guys to hold off for a second. Keenan, I'm looking to you because when I hear somebody say the problem is with the jurisprudence, and one of the ways in which we respond to jurisprudential problems is by looking to Congress and saying, Congress, fix this. come up with some solution that prevents this from ever getting to the point of litigation. So what do you have to say to that? Does that mean there is a role for Congress, and what should that role be?
Well, there's a role for Congress, but typically what happens is that it ends up spawning more litigation, which is the difficult part about it. If you look at the way that the End Racial Profiling Act itself is structured, it actually bans the practice of racial profiling, but to enforce it, you have to go back into court again. And I think this whole issue sort of ties into something interesting that came out in the discussion between Ted Shaw and Justice Sotomayor, when Mr. Shaw's implication was that it matters who is on the bench, okay? Because if you look at the whole notion of the way that bias is actually reflected in the law and how we've actually gotten to where we are in the Fourth Amendment, it's actually in some ways even worse that's been described. In the case of Virginia versus Moore, the Supreme Court held that the Fourth Amendment actually overrode a Virginia state statute that was designed to actually limit bias-based police stops, pretextual stops. So it's a really sort of insidious notion of what's going on here. And even if we pass the End Racial Profiling Act, it will be very interesting to see how all of this plays itself out in court, because the Supreme Court has already said that the Fourth Amendment exists out on an island, okay? And that attempts at the state level to try and undermine the whole notion of pretextual stops can actually be overridden by the Constitution. Now, whether Congress enacting a requirement, an anti-racial profiling requirement, and how that interacts with the Fourth Amendment jurisprudence is actually going to be an open question. This is one of those things that we've kind of left lying on the side of the table because nobody really knows the answer to that yet, but that is an interesting and important notion. A lot of this will also depend on of who your initial trial court judge is. It will also depend upon what circuit it's brought in, and it will also depend on the configuration of the Supreme Court once it gets there, because it absolutely, utterly will. If you look at a case like Wren in DC, or if you listen to the testimony of any police officer who would be brought to talk about profiling, the way that the vehicle code is designed currently under law provides an officer the opportunity to stop anyone for anything. So under the Wren case, which was an issue of fact that arose in Southeast DC, the question there was whether they stopped too long at a stop sign, not whether they ran the stop sign. So it's sort of you're darned if you do and you're darned if you don't. The issue, I think, is in some ways a more fundamental one, and it goes back to where we were in the summer of 2001. In the summer of 2001, you had a Republican president, this is sort of a Nixon goes to China moment, where you had a Republican president say, look, this is wrong and we have to stop this, okay? And that was a very important moment, because at that point, it was very much like the passage of the Civil Rights Act of 1964. There's a sea change. Something is wrong. We've got to stop this, okay? You got the entire Congress together who said, okay, we've known since the passage of the 14th Amendment that we have a problem here, okay? We're now going to fix it through a statute, okay? The problem that we have right now is that there is an arguable point within this administration and within the body politic about the use of race in law enforcement. Even if you divorce this whole issue from routine traffic stops and driving around, you still have the way that the issue manifests itself in terms of national security in the Arab American community. You still have the issue, the way that the issue manifests itself with respect to the Latino community and immigration reform. And we need to sort of get ourselves back to this whole moment of let's stop parsing this and let's talk about what we know is right and what we know is wrong. And I think that's the point that we actually need to get to, because otherwise you just end up back in court and you're arguing back and forth again, and you may win today, you may lose today, but we still haven't gotten to the point where our country sort of sees this situation clearly for what it is.
Well, speaking of seeing it clearly, that then takes me back to stakeholders and the community, because I think there's such a huge role for the community to play. You talked about the fact that there were 200 community members at this recent meeting. You talk about the stakeholders. Let's talk about what kind of impact community folks can have on these issues. Because part of what sometimes compels Congress to act and other lawmakers to act is because there's a groundswell of interest and folks on the ground saying, we've had enough of this. And I think it's those folks who get to say what we think is right and what we think is wrong. So talk about the role of the community and of stakeholders and of how it is necessary for that to represent a diverse set of point of views.
Okay. Well, so just to give a little contour to what the remedial process will look like, there's a facilitated series of town hall meetings that that will bring together anyone who wants to come. They're supposed to be held, there's supposed to be 5 of them, likely to be held in the areas where there's the highest numbers of stops a year, at least one in each borough. And these will be put together in consultation with stakeholders. So that the judge actually outlined a list that included a number of groups that wrote in amicus briefs in support of the plaintiff's remedial proposal. And that included criminal public defender offices like the Bronx Defenders, the Legal Aid Society. It includes really grassroots activist type organizations. It includes policy organizations, Drug Policy Alliance, it's a very broad range and a broad list. But I think most importantly, and if you talk to a room of lawyers who routinely litigate against law enforcement agencies, the key here is that it includes policing organizations. Because anything that you're trying to implement that doesn't include the law enforcement community and their families. One of the things that I think is really remarkable is the rate of domestic violence, suicide, and addiction in correction officers and police officers. And that's really, the public health risk of the siege mentality. And in New York, witness after witness said this is a paramilitary organization. That lens within which people are working day in and day out creates a psychological impact. And I think that if we want to think about solutions, and this is something that I think for people who are impacted, people who are afraid to leave their homes because they're afraid of the police, the people who are supposed to protect them, it's really hard to get there. But this is something that at least there's some commonality that we can think about coming together on. I think diverse stakeholders is essential because elected officials and the media and public opinion is not swayed just by people who are impacted. With stop and frisk, there was just such a groundswell. And I think what's remarkable about what Judge Shindlin laid out, she said, I want all these people to be involved, but really the important voice is the people who are affected, whether that's through plaintiffs' counsel, and obviously we represent a huge number of people who are impacted, but the organized constituency, we can't replace that necessarily, because there you have really unified goals and vision for what the reform should be, and people will put those forward. There will be a report, there will be an opportunity to comment, and it's really unique and innovative. I mean, she also put together a council of New York professors, a diverse group of professors, in New York, from New York City schools, to be who agreed to do this pro bono as consultants to the court and to the monitor in order to provide, what are the solutions? What is the training that needs to be done? What's the research out there? How can we actually solve bias-based policing? What is the cutting edge way of thinking about it? So, I mean, there's this prescription. And now we really are looking to it. I think has shifted a little bit to a political conversation as well. What's the team the mayor's going to put on this? The appointment of Commissioner Bratton was very controversial. He was in LA, and one thing that we really wanted to do differently was we did not want to end up years and years after litigation and a consent decree with people on the ground saying the police are still terrible, even though the court says there is technical compliance with this consent decree. So that's one of the reasons why this remedial process is put in place. That's what the ACLU in Arizona is doing. That's what the Department of Justice is now doing in all of their in their policing consent decrees, is including a community engagement component for pragmatic and political reasons. You need legitimacy on the ground. You need people to understand that change takes time. And by including them in the change process, you're more likely to get that willingness to stick with it. But then also, that's how you know what's actually happening. The monitor needs to be able to have people who can call him and tell them when there's a hotspot problem or when there's something going, when there's a rogue cop. And also for cops to feel like they can anonymously come forward to someone. Because we all know in these institutions there's the blue wall of silence and there's no way for them to come forward if there's a problem. The officers that did make those recordings and make them public have been, I mean, the way they've been treated and what's been dealt to them is quite remarkable as well. It's a whole nother conversation. And I think here it's like this convergence of this very public trial, an election, and this really incredible organized group of people that included grassroots folks, but also really savvy policymakers to take advantage of a moment. And I just, one thing I'll say that I thought, that I find remarkable is I was at this forum once, and this black woman stood up and said to me, "We really need a people's trial on the NYPD. We need a people's tribunal. What can we do to make that happen?" And one of the organizers, who's they packed the court every day. There was an overflow room. There were 2 overflow rooms some days, and he stood up and he said, "They tried. They wouldn't let the cameras in. They wouldn't let the TV crews in, but we made it the people's trial, and this was the people's trial on the NYPD." And that was just like, as a lawyer and as a litigator, you're like, oh, that's nice, right? Now, what change will actually be sustainable and what will happen from here, I think, I don't know if people will be as happy, because change takes a really long time, and I think right now people are hoping for a lot more change than just stop and frisk out of this decision, and we can't do that.
What kind of change are people hoping for?
I think, in our circumstances, I think that, again, we're dealing with a recalcitrant, non-cooperative defendant. And what was really interesting about our case, which I think the decision came down in May of 2013, the initial decision, where he was found to be violating the constitutional rights of Latinos, and then the order outlining the reforms came in October. The major difference here is that Arpaio is appealing the community engagement piece of the order. He has vehemently opposed from the beginning in engaging the community in any way over these processes of reforms. He's also appealing a smaller portion of the ruling. And I think, and the judge was hesitant. And he said it on the bench. I mean, he said, look, I'm concerned about writing in language about community engagement and forcing MCSO to the table when they have absolutely no interest in having a dialogue about this issue, which is a problem. And so recently we were at the point, probably about a couple of months ago, where leadership within MCSO hadn't even read the order. 6 months after the order had been, the injunction came down and the order outlining the reforms came down, the leadership, the chief deputies within the department had not read the order, and then were out there writing op-eds, criticizing, mischaracterizing, belittling the order. And the judge was fuming. He brought them in, he forced Arpaio to appear, he put them on the stand. He put Trombi on the stand as one of his chief deputies, and started questioning him about this order, and the judge was really offended by it. One of the outcomes of this is that he revised the community engagement piece and made some edits to that, changes to the actual order. And the biggest piece, initially, the judge, as part of the community engagement process, had created, it's a similar format as what happened in Floyd, where you have a series of district meetings. In this case, it's 7 district meetings. Then he also created a community advisory board that initially was going to have 3 representatives from the ACLU and 3 representatives from MCSO. That was the initial format. He changed that structure, and basically now it's a community advisory board with representatives from the ACLU. They're appointed from the ACLU, and they include, data experts, immigration attorneys, and organizers, one organizer. And then basically transferred the community engagement piece to the monitor, and at the cost of the taxpayers, which I think is really unprecedented, and it just goes to show, the difficulty of working with a a difficult party. And so now we have a situation where we have a community advisory board. That board, it spells out a process. They are going to be meeting routinely with community members. They're going to be accepting complaints. And then we have, the meetings. And so I think, that the question about, we're at the point where the question about implementation, we're not at the point yet about institutionalizing these reforms, but just how long and how realistic is it that we're going to implement them without sanctions and without, very cantankerous, process, confrontational process. But just to kind of, just to add to the role of the community in these reforms, I think what was really, what has been important is that this decision, the community, we wouldn't have been able to file this lawsuit had it not been for the community, and had it not been for everyone from volunteers videotaping the raids and stepping up to really provide the initial evidence that we needed to go to court. And so from the very beginning, they were very, very intimately involved in the litigation. As part of the litigation, we represent the largest immigrants' rights coalition, and then their individual plaintiffs as part of that litigation. But we have used, and the community has used this case as a way to engage in advocacy at the federal level and at the local level about why these practices are going to expose other police departments to increased liability in the SB 1070 world that we're still dealing with here in Arizona, which is a whole nother panel. But the reality is that Melendres and that decision really prevented the sheriff's office and MCSO from engaging in civil immigration enforcement, which means they can't stop you and question you about your immigration status and then detain you simply because you're undocumented, which is essentially what SB 1070 does. And it's being, Section 2B of 1070 is still being aggressively enforced in the state of Arizona. So those very same practices that led to the passage of 1070, because in Arpaio's practices, his practices were the model for SB 1070. His practices, he was cited, Russell Pierce, shown, they used him as a primary example of why other police departments need to be engaging in aggressive immigration enforcement. And now, obviously, under Melendres, he's now been prevented from doing that, but we have all of the other police departments throughout the state that are still aggressively enforcing it. And so the community has been involved in engaging in advocacy at the local level with the city councils to try to use this decision to limit the enforcement of SB 1070, and I think that's been an important conversation, and it's been an important conversation that the community has led about the criminalization of workers and the criminalization of immigrants in general. And so it has helped, document and demonstrate why 287G is not a great program, and ultimately led to some changes at the federal level where that program has not been expanded to other jurisdictions. And so I think, again, this community engagement piece is one that it's going to be very interesting to see how it progresses. It's very important. I mean, I think if the community, regardless of how much legal expertise and how much police expertise we have, if the community is not engaged in this and engaged and providing input on the practical consequences of these reforms, I think we're not going to be successful. And I think it's one of the things that, as part of the litigation, one of the reforms is it's as simple as not only are they collecting data, but now the officers, before they make a stop, they have to call dispatch and provide the reason for that stop to dispatch. Then they have to provide the driver with a receipt. So a driver receives a receipt. There are going to be audio, there's going to be video cameras in the cars. There's a pretty extensive list of reforms, and I think the community is going to play a very important role in making those reforms real. So that people understand how they're going to affect public safety and how they're going to really hopefully begin to end these biased policing and discriminatory practices.
Yeah, Keenan, you wanted to say something?
One of the things that I wanted everybody to really kind of hear is, in talking about the community engagement piece, this is actually a series of litigation-based remedies that follow on the kind of technical assistance that DOJ had been providing from the special litigation section in the Clinton administration that had been disabled under the Bush administration, okay? And all of what they're talking about is basically putting a community complaint review board in place, because when you have to remember that Floyd is sort of the back end of an incomplete effort. Okay, at the end of the Clinton administration, you had two different investigations going on of NYPD. One was for racial profiling in the Southern District, and one was for use of force in the Eastern District. When the administration changed, those two U.S. attorneys were replaced. Interestingly, there was a different approach with respect to those investigations of the NYPD. Mary Jo White, who led the Southern District, had racial profiling. Okay, that investigation went precisely nowhere. Zach Carter, who was then the U.S. Attorney for the Eastern District, strongly prosecuted the use of force investigation, okay? And they got almost to the door, and then boom, Zach Carter was shown the door, okay? So it actually matters whether you have local enforcement through the U.S. Attorney's offices or whether you have enforcement coming through Maine Justice. LA and New York are really interesting case studies because of the size of the police departments. I mean, everything in the world is going on there. I mean, they write, TV shows about what's going on in LA and New York, and everybody watches them, and then life, imitates art. But these are some of the things that we've actually been looking at for a very, very, very long time. And the whole idea of why you don't get community components coming out of consent decrees was actually very succinctly explained, but I want to make sure it gets illuminated, is because law enforcement does not want civilian oversight. And the extent to which law enforcement agencies have been militarized since 9/11 makes them even more resistant to civilian oversight. So that's one of the pieces that needs to really bubble up from the community level, that if you have issues with profiling, that's sort of symptomatic of other things that are actually going on within your police department. And it's all part of a very broad-ranging dialogue of what the interaction between law enforcement agencies and the civilian component really looks like. Because if you look at what's going on, the level of resistance with respect to civilian oversight and litigation around these cases goes much further than you could ever possibly believe. Okay, the level of denial, and we haven't even talked about what's going on in South Florida. Okay, that's an area where that's just, again, ripe with all of this. There's a great level of denial, and there's also a schism between management side groups and officer side groups with respect to the implementation of all of this reform. Okay, these law enforcement groups have actually gone so far as to openly lie in court. Okay, they've openly lied about attorneys who've actually brought these cases in Senate confirmations, you name it. I mean, the level of resistance to this is absolutely incredible. And it goes back to what I said before about there being a need to actually change our whole mentality about how we approach this. As a community, as a nation, we need to look at this and ask ourselves some very serious questions about what we want our police to do and how we want our police to engage. But we also have to have the same level of introspection within law enforcement agencies, within the officer-based groups, within the union side groups, within the management side groups, because the kinds of stress, suicides, domestic violence, addiction rates shows that this is a very dangerous job. And it's one of the reasons that we tried to actually engage law enforcement groups at the federal level around coming up with solutions, is to say the way that you're actually operating your police departments now makes your job more difficult and more dangerous. And it hits you right down to the personal level and in your own head and in your own family. And we're just starting to make headway with respect to these kinds of conversations. When you get a guy like Phil Goff, who is on the UCLA faculty and who's done a lot of psychological analysis of bias-based policing and the effects of it, when you put him on a panel with certain kinds of law enforcement witnesses, he drives them to distraction. Because Phil says, I'm going to get inside your head about what it is that you're doing and why you're doing it, and why we need to unravel this. Because we need to do this for our communities. You need to understand that you need to do this for our communities, but at a very fundamental level, you need to do this for yourself, because you're making your job very difficult, and you're killing yourself day by day by day with how this is being done. And this is a very active research area and a very active dialogue that's going on right now. And it's actually a very fascinating one. If you go back and you read some of the reports that are coming out of the Center for Community-Based Policing and these kinds of groups, that there's so much to this, and this is so tied to what's going on from what you see on TV to what happens inside an individual's home, that we're actually taking on a huge task when we start talking about racial profiling. Because when you begin to disaggregate this, this is, it's almost scary when you start talking about this. Because, again, the End Racial Profiling Act is great, but it doesn't necessarily speak to an individual interaction between a police officer and a member of the public. And in the case of a Sean Bell and in the case of an Amadou Diallo, where we had hearings, the Judiciary Committee had hearings, rump hearings up in New York. We had hearings out in LA. We've been to South Florida. To see the outpouring of what's going on in these communities, it's incredibly sobering to hear the level of resistance in some quarters in law enforcement is also incredibly sobering, because you realize that in many ways you're actually fighting for the lives of individuals, because it really comes down to things that are that deeply psychological. And what you're talking about in terms of implementing these decrees is very real, and I'm very happy to hear it. You're working with some great people, but it's the number of hurdles that we're talking about here are truly significant.
Yeah,
I just wanted to add real quick. In Maricopa County, one of the chief witnesses for Maricopa County Sheriff's Office was Sheriff Melendres, who was put on the stand and defended the sheriff's practices. This was in 2012. And a couple weeks ago committed suicide after it was revealed that he and other rank and file officers had been videotaping for years these stops. And it raises questions about why they were, did they recognize that this was completely unconstitutional, illegal behavior? For
which they could have been criminally prosecuted
exactly.
had it come to light.
Right, and there's a criminal investigation going on right now. The sheriff claims that he didn't know that these officers were videotaping these stops, and there's 900 hours worth of videos of these stops that we're going to have to sift through.
I'm going to go to Sunita because I know you had something, and then I want to end with a question to you, Devin, and then we want to get questions from you all, because I see head shaking and I see note taking, so I know you guys have some things to add.
Yeah, just two quick things that Keenan made me think about. One is that oversight is only is extremely controversial with law enforcement, but it's not if you take it to other public institutions, schools, hospitals. Nobody, of course you would have oversight of those agencies. What is so different here? So I would encourage us to start thinking about oversight as a broad community issue and as taxpayers and as a local city thing, to take it away from this special, unique role of law enforcement. And the second thing is that the whole idea of community engagement as a litigation remedy is really something that we're resurrecting from not just the DOJ consent decrees from the 80s, but from private litigation from the 60s, before there was this federalism concern at the Supreme Court level. And I think people are afraid of doing it because of what could happen, and many judges are afraid of it. But I would encourage all of you as future lawyers to consider it as an option if the recipe is there. It's not always going to be a good remedy, because it is also your job then to make sure that you get the community folks out, and to make sure that the downside is that the police officers are very well organized. They are a paramilitary organization and can show up at the town halls in a very, very organized fashion. So I just, like, my big call for lawyers these days is to think about it. And it is in all these consent decrees. And I think it's also really important for us to remember there's a distinction between, if you think about the arc and the history of policing litigation, civilian oversight bodies like the CCRB in New York, and there's one in almost every police department, have failed essentially because they've been co-opted by police chiefs. So what we're looking at now is what can you have that's different, and so now police office, agencies are moving towards more of an auditor and an ombudsman kind of model, which is very different than just looking at individual complaints. It's a more systemic kind of thing. So there are ways in which all these things relate, and so anyway, I think.
Devin, before we get our audience involved, one of the questions that I have for you, and I hear this theme throughout everyone's comments, so I have to go back to this, and particularly given that you're a critical race theorist and you're focused on the courts, is the foundation of this problem that we as a country do not know how to deal with race? And if that's the case, what does that mean for the courts? Because I have to say, when I look at this Supreme Court, I feel like they don't get it when it comes to issues of race. They just don't. What does that mean? What does that portend for us and for these issues? Because we can, as litigators, we can litigate these cases, we can have consent decrees, we can ask Congress to put all kinds of wonderful policy proposals in place, but if we are not understanding the importance of race and how it impacts us as a nation, where do we go from there?
That's an unfair question. So I think you're exactly right. I think it's fair to say that the criminal justice context is simply one context in which we're working out ideas about race and not necessarily doing a particularly good job about it. So you mentioned Phil Goff, a terrific scholar who is in the psychology department at UCLA. And if I were to critique those of us who think about criminal justice, it would be to say that I'm not quite sure that we've turned as aggressively to the domain of social psychology as we might. Meaning, over the past decade or so, I think lawyers and legal academics have been thinking about the mind sciences, and more specifically, studies of implicit biases, which suggest a profound disconnect between biases that we might have in our heads on the one hand and commitments about race that we might have in our hearts on the other. What do we do with that disconnect? Well, there is an awful lot of thinking about that in the context of employment discrimination, affirmative action, education, and the like, and I don't think that we've thought hard enough about how we might utilize that particular evidentiary basis in the context of criminal justice, and I think we all need to think harder about that. I don't know that it's an easy answer, but it's one place in which we might begin to develop a certain kind of consciousness around race that could be productive. The second thing I want to say while I have the mic pertains to, again, the Floyd litigation and the reasonable suspicion standard. In some ways, the Floyd litigation was fundamentally about keeping a particular opinion alive, Terry v. Ohio. So Terry v. Ohio is decided in 1968. And the litigation looks something like this. The government is saying that the stop and frisk practice does not need any justification. It doesn't need any justification because a stop is not a seizure, a frisk is not a search, therefore the Fourth Amendment doesn't have anything to say about it. That was what the government argued then. The defendant's argument was a stop is a frisk, a stop is a seizure, a frisk is a search, therefore it needs probable cause. Justice Warren splits the baby, like Solomon, and basically says a stop is a seizure, a frisk is a search, but reasonable suspicion is the standard. And he articulates that based on something like, the nursery rhyme you grew up hearing, Itsy Bitsy Spider. Well, a stop is an itsy bitsy. A stop is an itsy bitsy seizure, a frisk is an itsy bitsy search, so therefore you need an itsy bitsy standard, reasonable suspicion. Now, okay, so I'm being a little hyperbolic, but you get the idea. The reason I point that out is because subsequent to Terry, and indeed in the context of the litigation, people were arguing rightly that the reasonable suspicion standard would engender racial profiling. It's a weak standard. It would enable police officers to run amok on the street with respect to race. That's what it did. Fast forward to Floyd. Floyd was basically about Terry is good law, and it should be good law, but it's bad law in terms of what it's enabled on the street. And I want us to think hard about that. By way of analogy, think about Barkey and the diversity rationale. We're now vigorously defending diversity. Barkey was a loss. I mean, I can explain how if you want. It was a loss in so many ways, but we forget that as we vigorously defend it. I don't want the reasonable suspicion standard to become the new normal, that's the way we think about the permissible boundaries between the police and the people. So while we need to mark the more important victory, we need to continue to contest the reasonable suspicion standard. It is a doctrinal cover for racial profiling, and we need to understand that if we are to, I think, engage in robust conversations about policy interventions.
Thank you, Devin. I see a hand up already, so I'm going to go to you in the rear, sir. And could you stand up? And also, just let me remind folks, we want questions. We know folks have lots of opinions to share, but we want to get as many questions in as possible. So if you could succinctly tell us what your question is, we would love that. Thank you.
I'll do my very best.
Okay.
I personally, and I know I start with saying I'm personally, but I do have a question. Personally think that the Fourth Amendment was a stretch in the first place with applying it to the stop and frisk. I do think that a more appropriate analysis is the 14th Amendment. It seems as though, obviously, the Supreme Court is, consistently said that where there's a spirit impact but no demonstration of intent, therefore we apply a rational basis. Do you all believe that, if we, did away with this stop and frisk or entirely instead of a reform, or used a 14th Amendment application, then we would probably have a stronger argument in obviously, getting rid of this law?
Anita.
Well, our case is a 14th Amendment challenge. I mean, we are very squarely believe that this is a race case. So the class is anyone who's illegally stopped and frisked. That includes white people and anyone who's illegally stopped and frisked, with a subclass of Black and Latinos, and that's basic. It's like kind of swallows the whole. But yeah, I mean, the opinion's great. I love it because she's very intelligently kind of weaves together the law that's out there. It's very difficult to do that, but she does that very well. I know Devin has a lot to say on this.
Well, just very quickly, I think that opinion is a terrific opinion and a must-read, particularly for the 14th Amendment point. But you wouldn't want to structure an intervention around racial profiling on the 14th Amendment alone. Why? The ridiculous intent standard, that's A. And B, the 14th Amendment is not the primary vehicle for regulating police conduct. It doesn't carry with it the remedial remedy of excluding evidence. It's precisely because of the inability to exclude evidence in the Fourth Amendment context why we have the racialized prison industrial complex. So I think that we need to fight the Fourth Amendment fight and keep the 14th Amendment there as well. So I don't think it's an either-or proposition. And I think Judge Thindon made that perfectly clear.
And I should say that one thing that the local activists and the city council did is they passed a local law which actually was upheld yesterday, and I haven't read the opinion fully, but that instead of just an intent-based test, there's now going to be an effects-based test. So it's actually really incredible, innovative legislation. It's the first in the country. Local Law 71, I suggest that people look at it.
Yes, right here. Yes.
I've heard a lot about stop and frisk. I actually did some work on it last semester. But my bigger issue with this, working for the public defender's office this summer, is that I've noticed this problem is way bigger than stop and frisk. Right. It's such a systemic issue that if you are a person who doesn't look like me, you're much more likely to go to jail and I'm actually more likely to be selling drugs, doing drugs, carrying a gun. That's what all the evidence says. And
we're going to stop you on the way out.
That's fine. And my question is, are these reforms that are being put in place for stop and frisk, are they going to be able to be pushed further and affect these bigger issues of just stopping, not just stopping people, but the prison industrial complex that is affecting all people of color?
Well, I would say that I think what we're seeing is some shape shifting right now, especially with Commissioner Bratton. And the numbers of stop and frisk has gone down tremendously since he's come into his position. But he's shifting, right? Now it's raiding homeless shelters. It's going after quality of life offenses. It's picking up the marijuana arrest rate is still very high. They're pulling marijuana out of people's pants and saying, well, now you have open air drugs and we can arrest you to get a summons. So what Judge Shinlin did, which was very interesting, was say, look, we have this facilitated process, and if we can, there's some molding we may need to do, but perhaps we can convince the monitor that the reforms will affect some of these other policies. But that's one thing I think we need to be very clear about. The litigation takes a long time. It's very specific. We challenge a specific practice. This is only one strategy, right? You have to have a legislative strategy on the local and the state level. There's a whole state strategy around many of these issues. You have to have the research, the policy, and you have to have the organizing. The courts only provide, a sliver of a solution.
Alessandra, do you want to add to that?
Sure. I think certainly in the context of Arizona, where we are dealing with this issue of sort of the immigration enforcement and the pipeline to deportation, which is what, when you're stopped for a minor traffic violation and then end up in long-term detention, that is the pathway for thousands and thousands of immigrants. And I think, and I'm sure everyone here has their own opinion on data collection and its worth and its value, but I think for us, in terms of the data collection, it's very specific in that it's asking, and it mandates questions about passengers, when passengers are being questioned, when ICE is being contacted, how long the individuals are being detained. For us, that is all very valuable information, certainly in terms of how SB 1070 is being implemented and how, so I do think that some of the data collection in Maricopa County will help us. And I also think that for some of the reforms in Ortega-Melendres involving the discipline of the officers, how they conduct certain practices in terms of operations, everything from actual crime suppression sweeps, if they are going to be having them now, there are extra, there are requirements, things like worksite raids may be affected. So I think that it would help us in some of the other areas when it comes to this how immigration enforcement is being carried out.
Great. I see a hand here, and then I'm going to go here and there.
There we go. Thank you. I work at a small firm in Portland, Maine, and Portland, Maine, as well as Lewiston, Maine, are both refugee resettlement centers. And we're having and continue to have a lot of tension between the local population, the Portland Police Department, the Lewiston Police Department, the City Council, and the refugee population. Our firm does some civil rights work where we've been able to have the City Council, the police, our office, and the leaders from these various communities, including the Sudanese, Somali, and a few other nations from around the world, sit down together, and we've been able to have this dialogue. We also still have people being beaten down on the streets, and we're one of the only offices that dares to represent them because of how incestuous our legal community is with the small pool of people we have, and the fear of lawyers of being the repercussions from the police department, because we have to work with these cops for the next 50 years. So my question is what techniques have you guys developed, or would you suggest to quell the white population from thinking that these people are coming and sucking all of our resources, which is the view from a lot of the people that I grew up with who didn't grow up with a lot of money. They think that the resources are being drained. So what can I do, what can we do to help that when really they're building businesses and growing in the community? And then the other question is, what can we do to encourage other attorneys, other judges, other people in the community to dare to stand up for these people who really haven't been able to find a way to stand up for themselves?
Well, interestingly, Portland has a history of working with the Department of Justice with respect to racial profiling issues. And this would have been back in the late Clinton administration. They actually did get some technical assistance around racial profiling issues from the special litigation section. So they should actually have at least some sort of institutional memory about how to go back to that. The bigger issue is sort of one about a change of mind with respect to the population. To the extent that this reaches some sort of kind of, I think difficult, formal stage, you can always reach out to the Community Relations Service of the Department of Justice. At the time, the sheriff's departments go and talk about possible technical assistance with respect to how they develop policies around that. And then they can actually help with general outreach to the communities, to the majority community, to the minority communities, and to law enforcement. With respect to the whole issue of the legal community, I would point you back to what goes on with the Southern District of New York, the Eastern District of New York, the U.S. Attorney's offices, and Maine Justice around the NYPD. The reason that you never, ever, ever, ever had this happen, Floyd, they should not have been, should not have been the ones to actually bring this litigation. It actually should have been DOJ. Okay, DOJ should have done that. But because of the cozy relationship that you just described up in Portland, Maine, that exists around the NYPD, that's why this never happened. Okay, so I've now just made myself non-confirmable for anything.
You were already non-confirmable.
But I was already
Keenan.
non-confirmable. but the fact of the matter is, it's those cozy relationships which actually cause this problem. Okay, and lawyers, judges, particularly judges. The thing that you didn't get into was what actually happened to this judge. The Second Circuit they removed her from her own case. Okay, they removed her from her case, and you know why? Because the Second Circuit has the same lack of backbone that came from being AUSAs in the Southern District of New York. Okay,
I'm going to stop you there, Keenan.
That's why that happened.
I'm going to stop you there.
Okay, and so when you start looking at this is a really tough systemic issue. It's why death penalty appeals end up being brought by people from other regions of the country rather than from their states, Texas, Louisiana, Florida. We always hope that when President Kennedy started the Lawyers Committee back in the day and said, like, okay, the legal community needs to grow some backbone and start supporting the civil rights community, through this era, we need to go back and we need to, do a gut check and do the same kind of thing. Because what's happened now is that we've developed a specialized civil rights advocacy bar. Okay, but the fact that we've done that and the fact that some people, like the people on this panel, are willing to stick their necks out and make themselves unconfirmable does not absolve everybody else from their duty to have to go out and bring and defend these cases. Yeah. Okay, that's really what it comes back down to. So when you want to have a conversation with the rest of the members of your bar, say, you know what, I'm not your conscience. Okay, I am actually your conscience, but I'm not going to continue to act as your conscience. You live in this community, you have responsibilities to this community, you need to get out and do what's right. Okay? And if you can't go out and do what's right, remember the oath that you took to actually become a member of the bar, and then think about it again. And maybe you'll be successful, maybe you won't.
Just one other practical thing you could do is that there's the COPS office at the Department of Justice is head by a former police chief. And there are police chiefs, yeah, he's amazing. There are other police chiefs around the country who you could contact who might be willing to do an informal conversation with law enforcement in your community. They're not going to do anything public, but they might be willing to call and have a conversation. And that goes off, law enforcement to law enforcement, that's the key. You have to build those relationships and get those voices out there. The other thing I would say in terms of the lawyer thing, the legal community thing is, I'm at the Center for Constitutional Rights. That's actually something that we end up doing a lot, is coming in when other people won't litigate, and I know the ACLU does that a lot too. Yeah, that's sort of our thing, and we end up getting all these cases that are losers, but at least someone's standing up for people. So you can contact us. Anyone here can contact us. So yeah.
Thank you. Yes, sir. Can you stand up, please? Thank you.
Thank you. Our newspaper in New York, the Village Voice, actually broke. One of the first police officers that came forward with the tape recording. We have for years covered Sheriff Arpaio and his abuse of humanity in the jails and on the streets. And his election margin has decreased every time that he has run. And I'm disappointed that in all of these strategies that are being cited here, none of you have said that you needed to reach out to the press and get journalists and reporters and editors involved with making your case. Because the case, in many of these instances, is overwhelming once it's explained to people. And yet, you know, we've got a panel of 5 very bright people. We've been through the entire session, and you haven't mentioned the media once.
I won't say that one of the things that I have to do is read an op-ed piece that we're actually trying to place around this particular issue next week, and another issue. I think one of the things that for us, for a lot of the lawyers, they spend a lot of time down in the weeds. On the legislative side of things, though, we actually have communications offices, and we do this quite a lot. It's one of the things that we don't necessarily, talk about openly all the time, but I've always looked forward to reading the Village Voice stories about, all of this. But that's actually part of strategies where around the Anti-Racial Profiling Act, for example, we have been able to place op-eds in papers across the country where we needed to expand opinion thought. For example, we've worked with people like the chief of Salt Lake City around the issue of immigration enforcement, to actually have him write op-eds and to place them in different kinds of papers, so that different kinds of points of view are brought up among sympathetic editorial boards. So I mean, it's actually something that we actually are engaged in. I'm glad that you raised that point. But typically, this comes not from the litigators, but it actually comes from more the policy people.
But I will also say that with respect to the Brennan Center and the work we do, and I know I was the moderator and didn't get to talk about all of our substantive work, but we are a national think tank, as you know, and we actually utilize what I like to call the triumvirate of strategic communications, policy and advocacy, and litigation with respect to all of the issues that we work on. So it is a core part of our approach whenever we attack any of these issues. But you're right, it's a good point. Unfortunately, we can never get to everything that we want to talk to up here, but I'm glad that you brought that up. I think I have time for one more question, or more. More? Okay, good. Yes. You're on. Oh, you're waiting for the mic. Okay.
Thank you. Thank you so much for this great panel. Quickly, I had a question about, I take really the great point that, we have to be cognizant of the fact that some of these precedents that we're clinging to with dear life, like the reasonable suspicion standard and Terry, it might not be the best legal framework out there, but given the court that we have, do you see any opportunities for achieving victories that could lead to a stronger framework that would be able to help prevent bias-based policing, or do you think of this more as sort of an educational component that with a longer-term litigation strategy in the court? Sometimes in the Fourth Amendment, we have been able to find a fifth vote amongst, the conservative justices like Justice Scalia in this term's smartphone search case. I think we hope for some conservative votes there. And I'm just wondering if you see any opportunities in this court on this topic.
No.
And you're probably asking for more elaboration. No, so quick. I think no is the short answer. But I do want to say 2 very quick things. I think part of what you're trying to do as well is raise public awareness. So police officers have to ultimately say, I'm not going to racially profile, even though I can. I think that's basically what the universe in which we're operating. That's point 1. But the other point is that the Supreme Court isn't the only site for making law. And so if we understand the Fourth Amendment backdrop, when we move to the state arena, we can get something else, which is to say there's absolutely nothing that prevents a state from saying our standard is probable cause, not reasonable suspicion. That is not inconsistent with constitutional law. Right. States can do more. States can always give us more rights. They can do that legislatively or a matter of judicial determination. If we naturalize the reasonable suspicion standard as the natural border between people and the police, then there's no incentive for states to do that. So we need to problematize it, defend it when we must, as we did in the Floyd litigation brilliantly, but also make clear that it's a problem, and if you're interested in thinking about improving the scenario, then maybe you ought to think about probable cause, which, by the way, is not a particularly robust standard anyway, but it's a little bit better.
I hear somebody's phone, but I won't call you out. Do we have a, oh, I was just, that was good timing.
That was the timer.
That was good timing. I've been given my stop, but I think we got to everybody's questions. I didn't see anybody jumping. Thank you all so much. This was a great conversation.